Hello! Welcome to the Study With Me series of Law School Buddy. I have prepared audiobook materials following the syllabus of the Philippine bar exams dedicated to our law school students. I hope that this audiobook can help with your study and review. Let's begin. This episode will cover Property Law, Title 7, Easements of Servitudes, Chapter 2, Legal Easements, Section 4, Easement of Party Wall, Article 658. The easement of party wall shall be governed by the provisions of this title, by the local ordinances and customs, insofar as they do not conflict with the same, and by the rules of co-ownership. Article 659. The existence of an easement of party wall is presumed, unless there is a title, or exterior sign, or proof to the contrary. 1. In dividing walls of adjoining buildings, up to the point of common elevation. 2. In dividing walls of gardens or yards situated in cities, towns, or in rural communities. 3. In fences, walls and live hedges, dividing rural lands. Article 660. It is understood that there is an exterior sign, contrary to the easement of party wall. 1. Whenever in the dividing wall of buildings, there is a window or opening. 2. Whenever the dividing wall is, on one side, straight and plumb on all its facement, and on the other, it has similar conditions on the upper part, but the lower part slants or projects outward. 3. Whenever the entire wall is built within the boundaries of one of the estates. 4. Whenever the dividing wall bears the burden of the binding beams, floors, and roof frame of one of the buildings, but not those of the others. 5. Whenever the dividing wall between courtyards, gardens, and tenements is constructed in such a way that the coping sheds the water upon only one of the estates. 6. Whenever the dividing wall, being built of masonry, has stepping stones, which at certain intervals project from the surface on one side only, but not on the other. 7. Whenever lands enclosed by fences or live hedges adjoin others which are not enclosed. In all these cases, the ownership of the walls, fences, or hedges shall be deemed to belong exclusively to the owner of the property or tenement, which has in its favor the presumption based on any one of these signs. Article 661. Ditches or drains, open between two estates, are also presumed as common to both, if there is no title or sign showing the contrary. There is a sign contrary to the part ownership, whenever the earth ordered removed to open the ditch, or to clean it, is only on one side thereof, in which case the ownership of the ditch shall belong exclusively to the owner of the land, having this exterior sign in its favor. Article 662. The cost of repairs and construction of party walls, and the maintenance of fences, live hedges, ditches, and drains owned in common, shall be borne by all the owners of the lands or tenements, having the party wall in their favor, in proportion to the right of each. Nevertheless, any owner may exempt himself from contributing to this charge by renouncing his part ownership, except when the party wall supports a building belonging to him. Article 663. If the owner of a building, supported by a party wall, desires to demolish the building, he may also renounce his part ownership of the wall, but the cost of all repairs and work necessary to prevent any damage, which the demolition may cause to the party wall, on this occasion only, shall be borne by him. Article 664. Every owner may increase the height of the party wall, doing so at his own expense, and paying for any damage which may be caused by the work, even though such damage be temporary. The expenses of maintaining the wall, in the part newly raised, or deepened at its foundation, shall also be paid for by him, and in addition, the indemnity for the increased expenses, which may be necessary for the preservation of the party wall, by reason of the greater height or depth which has been given it. If the party wall cannot bear the increased height, the owner desiring to raise it shall be obliged to reconstruct it at his own expense, and if for this purpose it be necessary to make it thicker, he shall give the space required from his own land. Article 665. The other owners, who have not contributed in giving increased height, depth, or thickness to the wall, may nevertheless acquire the right of part ownership therein, by paying proportionally the value of the work, at the time of the acquisition, and of the land used for its increased thickness. Article 666. Every part owner of a party wall may use it in proportion to the right he may have in the co-ownership, without interfering with the common and respective uses by the other co-owners. Section 5. Easement of light and view. Article 667. No part owner may, without the consent of the others, open through the party wall any window or aperture of any kind. Article 668. The period of prescription for the acquisition of an easement of light and view shall be counted, 1. From the time of the opening of the window, if it is through a party wall, or 2. From the time of the formal prohibition upon the proprietor of the adjoining land or tenement, if the window is through a wall on the dominant estate. Article 669. When the distances in Article 670 are not observed, the owner of a wall which is not party wall, adjoining a tenement or piece of land belonging to another, can make in it openings to admit light, at the height of the ceiling joints, or immediately under the ceiling, and of the size of 30 centimeters square, and in every case, with an iron grating embedded in the wall, and with a wire screen. Nevertheless, the owner of the tenement or property, adjoining the wall in which the openings are made, can close them should he acquire part ownership thereof, if there be no stipulation to the contrary. He can also obstruct them, by constructing a building on his land, or by raising a wall thereon, contiguous to that having such openings, unless an easement of light has been acquired. Article 670. No windows, apertures, balconies, or other similar projections, which afford a direct view, upon or towards an adjoining land or tenement, can be made without leaving a distance of 2 meters between the wall in which they are made and such contiguous property. Neither can side or oblique views, upon or towards such conterminous property be had, unless there be a distance of 60 centimeters. The non-observance of these distances does not give rise to prescription. Article 671. The distance referred to in the preceding article shall be measured in cases of direct views, from the outer line of the wall when the openings do not project, from the outer line of the latter when they do, and in cases of oblique view, from the dividing line between the two properties. Article 672. The provisions of Article 670 are not applicable to buildings separated by a public way or alley, which is not less than 3 meters wide, subject to special regulations and local ordinances. Article 673. Whenever by any title, a right has been acquired to have direct views, balconies or belvederes, overlooking an adjoining property, the owner of the servant estate cannot build thereon, at less than a distance of 3 meters, to be measured in the manner provided in Article 671. Any stipulation permitting distances less than those prescribed in Article 670 is void. Section 6. Drainage of buildings. Article 674. The owner of a building shall be obliged to construct its roof or covering in such manner that the rain-water shall fall on his own land, or on a street or public place, and not on the land of his neighbor, even though the adjacent land may belong to 2 or more persons, one of whom is the owner of the roof. Even if it should fall on his own land, the owner shall be obliged to collect the water in such a way as not to cause damage to the adjacent land or tenement. Article 675. The owner of a tenement or a piece of land, subject to the easement of receiving water falling from roofs, may build in such manner as to receive the water upon his own roof, or give it another outlet in accordance with local ordinances or customs, and in such a way as not to cause any nuisance or damage whatever to the dominant estate. Article 676. Whenever the yard or court of a house is surrounded by other houses, and it is not possible to give an outlet through the house itself to the rain water collected thereon, the establishment of an easement of drainage can be demanded, giving an outlet to the water at the point of the contiguous lands or tenements where its egress may be easiest, and establishing a conduit for the drainage in such manner as to cause the least damage to the servant estate, after payment of the property indemnity. And that is the end. If this audiobook has helped you, please comment down below and like and share our video to someone who might need it. Thank you so much for making us your law school buddy.